So one of the intellectual property rights that is protected by the Intellectual Property Code is the industrial design. Now, industrial design as defined by RA 8293 as amended by RA 9150 is any composition of lines or colors or any three-dimensional form, whether or not associated with lines or colors, provided that such composition or form gives a special appearance to and can serve as a pattern for an industrial product or handicraft. So in this case, an industrial design is the ornamental or aesthetic aspect of an article. Design in this sense may be three-dimensional or two-dimensional. Three-dimensional refers to the shape or the surface of an article, while two-dimensional refers to the patterns or lines of colors. But under the law, not all industrial designs shall benefit from the protection. Only those industrial designs that are new or ornamental should benefit from the protection under the law. Industrial designs dictated essentially by technical or functional considerations to obtain a technical result, or those that are contrary to public order, health, or morals shall not be protected. Of course, to be granted with the benefit of protection under the law, an application for the registration of the industrial design shall be filed, and the contents of the application or the application shall contain a request for registration of industrial design, the information identifying the applicant, an indication of the kind of article of manufacture or handicraft to which the industrial design shall be applied, a representation of the article of manufacture or handicraft by way of drawings, photographs, or adequate graphic representation of the industrial design as applied to the article of manufacture or handicraft, which clearly and fully discloses those features for which protection is claimed. And the name and address of a creator, or the applicant is not the creator, then a statement indicating the origin of the right to the industrial design or layout design registration. Now, of course, the application may also be accompanied by a specimen of the article embodying the industrial design and shall be subject to the payment of the prescribed fee. So, after the application is filed, the application will then go through an examination. Now, in the examination process, the office, the IPO, shall accord as the filing date the date of receipt of the application containing indications allowing the identity of the applicant to be established and a representation of the article embodying the industrial design or the pictorial representation thereof. Now, if the application does not meet these requirements, then the filing date should be that date when all the elements specified in Section 114 are filed or the mistakes corrected. Now, otherwise, if the requirements are not complied within the prescribed period, then the application shall be considered withdrawn. After the application has been accorded the filing date and the required fees paid on time, the applicant shall comply with the requirements of Section 114 within the prescribed period. Otherwise, the application shall be considered withdrawn. Now, the office shall examine. This is the purpose of the examination process conducted by the office. This is to examine whether the industrial design complies with the requirements of Section 112 or the definition of an industrial design, and of course the substantive conditions for protection. Now, after the examination, if the application is found compliant with the requirements, the office will then order the registration be effected in the industrial design and cause the issuance of an industrial design certificate of registration. Otherwise, if it is not compliant, then the office shall refuse the application. Now, the form and contents of the industrial design shall be established by the registrations, provided, of course, that the name and address of a creator shall be mentioned in every case. Now, the registration shall be published in the form and within the period fixed by the regulations. The office shall record in the register any change in the identity of the proprietor of industrial design or his representative if proof thereof is furnished to it. Now, a fee shall be paid with a request to record the change in the identity of the proprietor. If the fee is not paid, then the request shall be deemed not to have been filed. In such a case, the former proprietor and the former representative shall remain subject to the rights and obligations under the code. Now, anyone may inspect the register and the files of registered industrial designs, including files of cancellation proceedings. So there is no there is no prohibition for anyone to inspect the register and the files of registered industrial designs. So the question now then would be, is the protection granted by the law forever? The answer, no. The registration of an industrial design shall be for a period of 5 years from the date of the filing of the application. And this registration may be renewed for not more than 2 consecutive periods of 5 years each upon payment of a renewal fee. Now, this renewal fee must be paid within 12 months preceding the expiration of registration. What if the registration, in cases where the registration has expired and the renewal fee was not paid? Does that mean that the industrial design is no longer protected by the law? No. The law grants a grace period of 6 months for the payment of fees after such expiration upon payment of a surcharge. So this means that even if the registration has expired, there is still a grace period of 6 months, where a renewal fee may be paid or a surcharge may be paid for the renewal of the registration of the industrial design. Prior actual use principle is not a primary basis in acquiring ownership of an industrial design, because the right of protection on an industrial design is not based on as to who was the first to use the industrial design, but it is who was the first to create the ornamental design or the aesthetic aspect of the article. It may be a determining factor in an examination of an application, but it is not the primary basis in acquiring the ownership, because again, the right of protection of an industrial design is not as to who first used the design or the ornamental design, but as to who first created the ornamental design. Can the industrial design registration be cancelled? Yes, of course, on the following grounds. 1. If the subject matter of the industrial design is not registerable within the terms of the definition of what an industrial design is and the substantive conditions for protection. 2. If the subject matter is not new. And 3. If the subject matter of industrial design extends beyond the contents of the application as originally filed. Now, where the grounds of the cancellation relate to a part of the industrial design, then the cancellation may be effected as to that extent only. So, if the cancellation or the ground of the cancellation does not involve the whole industrial design but only a part, then the cancellation may only be effected only to that part that must be cancelled, as to the ground that is related to such part.